or good afternoon from Pennsylvania. I am privileged today to be able to moderate this panel on points of view of copyright enforcement. Our session today is sponsored by Image Rights, who we greatly appreciate their sponsorship, whom without their support, this session would not be possible. So this morning, I'd like to introduce you to three noted copyright people. The first person to speak this morning is Katie Rowland with the Copyright Office, followed by Joshua Galbert, who is an attorney practicing in the Northeast of the United States. And we also have with us today Ewan Vanderbrand, who is the founder of Permission Machine, and he is from Belgium. So with that, I'd just like to share a couple of points. Two articles that I recently reviewed had some pretty interesting facts that talk about just how much the need for copyright enforcement is because of how image theft has exploded. But I do note the two articles here from gathering 2018 data. For every image used illegally, photographers and image agency lose about $446. And 64% of professional photographers have had their images stolen. Now, these articles contain a great deal more information, but just a couple of facts from those articles that I believe will make it very necessary to learn the information from our panelists this morning. From the second article, some pretty interesting information is almost nothing of value online operates without the help of photos and illustration. And with that being said, and the images shared on the internet, the majority of them are used without a license. 3 billion images shared on the internet daily, with 85% of them not having a valid license. And that makes it about 2.5 billion images stolen on a daily basis. Well, with that in mind, we're going to turn it over to Katie to give us some points of view from the Copyright Office.
Thanks very much. It's great to be here virtually today to talk about these issues. Before I get started on enforcement issues, I wanted to just quickly tell you what the Copyright Office is, for those of you who are not super familiar with us. We are the federal agency that is primarily charged with administering the Copyright Act in the United States. We obviously are the ones who do registration. So if you're ever trying to register your claims to copyright, we do that. And we also do a lot of policy work, and we work with Congress advising on copyright law. And we also are in the Library of Congress, so many of the things that you file with us become part of their collection through the mandatory deposit procedures. So we have a lot of really interesting things that go on in the Copyright Office, and we always like to come and talk to people and try to help them learn more about copyright and learn more about what they can do to, work with the system. So today we're talking about enforcement. And I wanted to mention a couple of things that the Copyright Office has done or has, looked at and had considered when thinking about these issues. And also I wanted to kind of give a little background on some of the issues that happened before enforcement, but just very briefly. I will tell you that we have done a lot of study in the Copyright Office on actually visual artists specifically and copyright issues. We have a letter that we have up on our website, copyright.gov. If you are interested in looking at it, it has basically sets out the landscape of issues that face visual artists these days, and runs down a bunch of different problems that have been faced by the industry and the people who work in it. So, one of the big issues is, as Sonia was saying, this kind of a lot of use of different images that were not licensed online. And there are many reasons for that. Some, are bad, some are not bad. So there are people who willfully do that, but there are also people who are confused or misunderstand the law. And so there are kind of there's an educational issue going on as well with online infringement. So One of the issues that comes up is Orphan Works. And if you haven't heard of Orphan Works before, they are those where you cannot find the owner of something, or you can't find them, or you don't know who they are. And so those happen a lot online because things get removed. The metadata is either never there or is removed. And so that's a problem. You also have issues about people who put these disclaimers on their websites. People like to put these little things that say, I'm not copyright enforcement, like I'm not intending to commit copyright infringement. And then they usually cite this weird law that doesn't exist, right? So they will cite, it'll look very fancy, like, 12 USC 70 million or whatever. And so you might think that it is actually a thing. It's not a thing, but people are actually confused. So one of the things that we really are interested in doing is education, because that will help with enforcement, hopefully, overall. Then there are other issues that, that education will not always fix, right? So there are infringement issues out there that you would need to go a different route down than others than just education. So one of them is Section 512, which we are actually engaging in a lot of education right now as well. But, that is a subject that I believe is going to be a whole panel in your program. So I'm going to only briefly mention it. Section 512 is part of the Copyright Act that provides this notice and takedown system, a system in which if there's infringing content posted on the web, then the copyright owner can request that it be taken down. And then, from the ISP, the website, whatnot. And then if they do, then the person who put it up there has a chance to do a counter notice, and then it will be returned back unless there's a lawsuit, basically. And so that is the DMCA in a very, very small nutshell. There are so many other parts of it, but the DMCA is Section 512 in a nutshell. But what I wanted to mention is that the Copyright Office studied it for a long time. We were asked by Congress to do a report on it, and so we in fact did. We held a bunch of roundtables. I believe we had over 90,000 public comments on the study over the years, and eventually we came out, it was last April, I believe, end of last April, we came out with a report which talked about how it's functioning. And we had some recommendations in there, about looking at different ways of whether there should be changes or not. And in fact, there have been some hearings on the issue too. So 512, it is kind of soldiering along. It's been a while. And so Congress is definitely interested in it. And as I said, they had a hearing, this was like a month and a half ago, and they may have more. So it's something to watch on the Hill. So when you have your other panel that kind of dives deep into all of the 512 issues, if you are really interested in that, you should pay attention to the judiciary committees in both the House and the Senate, because they might be looking at it, possibly. So in addition to Section 512, one of the things that we are looking into is small claims. And so what is a small claim? A small claim is not small, in value, in your personal value, but it's small in monetary value. And there is an issue with a lot of copyright owners who have these claims that are worth, a couple hundred, couple $1,000s, and there are infringements. And the concern right now is the only way that people can go and enforce their rights is through federal court. So the Copyright Act requires you to go to federal court to bring your cause of action for copyright infringement. And as well as if you think that you have made a fair use and you want to do a declaratory judgment action. So you have to go to federal court, which, as you may imagine, is a bit daunting to many people. So it's a big process often. So people don't often go there. In fact, when we had a study of small claims, we had a survey submitted to us that said that almost 45% of creators didn't bother to even bring a lawsuit because they just thought that the legal costs would be more than the damages they would be able to get. So there's information out there talking about how daunting it can be. It can cost a lot of money. There are studies out there saying that cases that have a worth less than $1 million, which is a lot more than a small economic claim, those would still be around $250,000 to litigate. So it's a process that is very expensive, and it can drag on for a long time. It can be, years, and there can be discovery, and discovery can be daunting for some people who don't have representation, or they just want to be creating their works, right? And having the business, they don't have the extra time to become litigators and learn the federal rules of evidence or hire a lawyer who may or may not take their case. So Congress asked us to look into that and see whether or not we thought there could be a different way. And so we studied a bunch of different options, looked at the idea of turning it, making a state court cause of action for certain types of works, or putting it in a different place in the organization. We have this thing called the Copyright Royalty Board in the Library of Congress that does rate setting kind of issues, like decides the royalty rates for certain things. And that was kind of bandied about. But eventually we landed on the idea of having a voluntary tribunal within the Copyright Office. And the reason we thought that is because the Copyright Office obviously is expert in copyright, we think. And so there are people here, we could hire people to be kind of tribunal members who would be able to look at these. It would be somewhere where we could create something that is streamlined, so that you wouldn't have to have all of the discovery, possibly, as you might have in a normal federal proceeding. And because we thought that was the best place for it, we decided it had to be voluntary. And that is because in the Constitution, you have things that are very important that you need to uphold. So for example, Article 3 has the federal courts, and so we couldn't run afoul of that. We're not creating a new Article 3 court in the Copyright Office. There are the rights to a jury that could, present themselves. So you want to make sure that people would be voluntarily entering into this. And there are also kind of due process issues. So it was really important for us to make it voluntary. We actually offered 2 suggestions for making it voluntary. One would be an opt-in and one would be an opt-out. So we outlined actually both options in our report that we provided back a while ago. So when we did this, we also looked at the different kinds of claims. It was a very interesting procedure, but in the end, we had a report that recommended this voluntary program in the Copyright Office that would have limited discovery, would have not really any in-person hearings, hearing upon request essentially, and something where we would have some educational component to it, and there would be a staff attorney that kind of operated somewhat similar on that, would be someone who could help with people who are trying to file things. So we did that, and then Congress, I guess, thought it was a good idea. So over the years, they have introduced legislation a couple of times in both the House and the Senate, and the most recent one, the one that has gotten the farthest, is called the CASE Act. It actually passed the House last year in 2019, and it passed out of the Senate Judiciary Committee. And so it is in the Senate, the bigger Senate right now. And that act has a lot of it is based on our report, not totally, but it does, track a lot of the things that we had recommended. It is a voluntary tribunal in the Copyright Office, and it would have 3 copyright claims board officers, I suppose you would call them. And there is a monetary limit of $30,000 for a proceeding, and a limit of $15,000 for statutory damages per work. So that's lower than if you went to federal litigation. And it limits kind of the types of things you can do. So it's not going to be, I bring my copyright infringement case, and then I'm going to bring this other kind of ancillary contract to dispute. And it tries to be a little bit streamlined in that way. And so that is the overall look of it. It is the last version I saw, it's an opt-out version, so that you would get notice of it if you are the person on the other side. You get notice of it, and then you have a certain amount of time to opt out, and otherwise you are in the system as far as that particular proceeding goes. So that is the CASE Act in a nutshell. I will say that we at the Copyright Office, we definitely think a small claims process is a good idea. But we have not made any official statements about anything thus far, but I'm happy to discuss, parts of it or whatnot if anyone has any interest. And as far as 512 goes, we shall see.
I'm going to jump in only because, as we discussed briefly beforehand, I'm not as excited about the Case Act as I think a lot of people are. And I think it's worth discussing its potential shortcomings. I am familiar with the Copyright Office's determination of cost of litigation, and certainly it is true that for a lot of complex cases, they can be very expensive to litigate, and particularly on the defense side. But many copyright cases are on the plaintiff's side conducted on a contingent fee basis. Many such cases in the infringing image world, where my photograph is put up on somebody's website, are done on contingent fee basis. So for the plaintiff, there is usually very little risk of attorney's fees, and the costs of filing in the federal court are $400, plus this cost of service of process. But the way the Case Act is written, you'd still have to pay a filing fee of at least $100 plus the cost of service of process. So there's not that much to be gained in terms of its low cost for the plaintiff. Potentially a lower cost for the defendant. But I would suggest that because of the optional system, I find it very difficult to imagine an informed plaintiff and an informed defendant who would agree to actually go through the small claims process. For a plaintiff, there is no advantage to bringing an action there if the work is registered before infringement. The Copyright Act permits statutory damages of up to $30,000 for if brought in the federal courts as normal, and up to $150,000 if you can prove willfulness. But the small claims limits the damages to $15,000. So in my experience with image claims, and I should add that my experience is colored by the fact that I'm quite selective about the ones that I'll take. Because if I'm working on a contingent fee basis, I don't want to lose. I want surefire wins. So the ones that are broad are the ones where you're like, yeah, this is a pretty clear infringement. This is my image. There it is on the website. There's really not any questions, or very few questions about it. But as a consequence, the big factor is how much money can I theoretically scare the defendant into thinking he'll have to pay when he loses? And I want the maximum. I want to be able to say $30,000 per work, or $150,000 if I can prove damages. To say, I'll voluntarily limit the amount of damages I'm asking for to $15,000 is simply to disarm myself. Now there is an exception to this.
I would point out to counter that discussion. There are actually kind of a set of things in our proposal, and I believe in the Case Act, that would be an incentive to go there for both sides. So first of all, you mentioned the filing fee, but the filing fee, if you think of in federal court, $400 out of like $250,000 is not exactly what it's going to make you decide whether or not you're going to go to court. So the filing fee, I don't think makes up the vast majority of the costs in federal litigation. What does is motion practice and discovery can take up to 90% of your costs, which can be very costly. And what the Case Act does is it's going to limit the kind of amount of that. There obviously would have to be regulations kind of hashing this out, but there are so the whole point is for it to be streamlined and not last as long and not have so many of the trappings of federal court while still being fair and having people be allowed to present their sides. And as far as contingency fee cases, that is absolutely true. Some people do take things on contingency fee, like you, but there are not a ton of people to do that. And when we heard from the participants in our study, people would say that basically if their claim was under, I think it was, I'm going to guess here because I can't remember exactly the number, but it was between $30,000 and $40,000 that lawyers were not taking them. And so the concern for them was, well, I can't get a lawyer, I can't do it myself. So that is a big problem for smaller creators, and not just the creators, but the potential defendants who are actually making a fair use, because there are people who are making a fair use who want to have a declaratory judgment action going on, and there you're not going to get really a contingency fee for that. I mean, that's a different situation altogether.
Sorry, let me address those in turn. One is, and I think this is an important distinction, in the context of these, what I'm speaking of in terms of image infringement. I'm a photographer, I took an image, it's over there on that guy's website, I didn't give him a license, for example. Those cases are quite clear. I have litigated, or rather, I should say, I have acted for rights holders in dozens of such cases. I've never gotten to discovery because there's not really any questions. I own it, here's the registration certificate, there it is. There's very little to discover. And with respect to the finding of contingent attorneys, I'm not aware of anybody who does those kinds of cases who doesn't do them on contingent fee basis. And most of them, it's very hard to value these claims up front, but the bulk of them are not going to be guaranteed to be above $30,000 or $40,000, unless you have multiple infringements, multiple works infringed. You're looking at statutory damages and attorney's fees as the cudgel. Now, you are with respect to a fair use claim on the defendant's side. Yes, I can see why defendant would say, I'd like to bring this in small claims because it'll be cheaper in the federal court. But again, it's voluntary. If I'm the putative plaintiff, in other words, the receiving end of the declaratory judgment, I'm going to opt out. No, I want to do this in federal court. You'll have to incur all of those costs because defendants or plaintiffs in a declaratory judgment action have to pay their lawyers out of pocket. So their incentive is to settle as quickly as possible and not drag this out. It's, as a tactical matter, the one incentive that I would see that would bring a plaintiff to the small claims court is my work wasn't registered before infringement occurred. And as a result, I'm not entitled to statutory damages and attorney's fees. But magically, under the Case Act, the small claims court can award up to $7,500 for infringement of works that were not registered prior to infringement. But again, if I'm the defendant, why in the name of God would I agree to this? Because if I don't agree to it, they'll have to bring an expensive, lengthy case in federal court to try and get actual damages of $60. So all I would say is, no, I'm not going to agree to that. You can bring your basically worthless suit in federal court, which you almost certainly won't do, and therefore I'll never have to think about this again. The only time I can see this being moderately useful is essentially based on the ignorance of the parties. If somebody doesn't realize the advantage of not going to the court, going to the small claims division. It's not to say that it's impossible. I just think that if you had a fully educated group of parties, nobody would agree to this.
I just want to say that I know that we have to move along, and so I don't want to take up too much time, but I will say that we have I think it's like a 160-page report on copyright.gov that you can read that I think has a very good rebuttal of many of these points that Josh is bringing up. And so to the Copyright Office, in short, there is definitely a benefit to giving people access to enforcing their rights or to, proving that they have a fair use defense. That right now they don't, a lot of people they just don't have the way to do it. And this would provide them with a way to get some sort of relief there. And there are benefits to both sides to participating. And because I want to not dominate this conversation and let everyone keep going to the other discussions, I would just invite you to go look at our report because we go through them in exquisite detail, and I think very persuasively.
Okay, great.
I would argue the persuasive point.
Yeah, I'm just going to bring it back to Joshua for a second then. Josh, could you talk briefly about the other case that we are going to introduce the audience to, and then we'll get to Ewan's participation as well.
We had talked about a couple of cases. Are we talking about Fourth Estate or are we talking about Breitbart?
You choose.
Okay. I can run them through fairly quickly because Fourth Estate is important, but very quick. Fourth Estate versus Wall Street was decided by the Supreme Court last year, and very briefly, it decided a question that's been dogging us for decades, which is, can you bring the suit once you've can you only bring suit once you've received a registration certificate from the Copyright Office, or can you bring it once you've just sent your application papers in? And we had a circuit split, meaning some courts had said one way, some the other for a long time. And finally, the court unanimously ruled, no, you got to actually get a registration certificate from the Copyright Office before you can bring suit. This is mostly procedural, but has some important consequences if you're getting close to the statute of limitations. So I draw everyone's attention to that just because it's now finally settled, and it is an important matter in litigation issues. The more interesting one, and the one that I think UN is going to talk about at some more length, at least conceptually, is the question of embedding works. It has long been thought for perhaps 10 years that the rule was as to whether or not a use was infringing, depended on whether or not that work, like an image, rested on the defendant's server or somewhere else. This is what's known as the server test, and it was sort of adopted by the Ninth Circuit out in California about 12 years ago in a case called Perfect 10 versus Amazon. And the position was, look, if it's only infringing fundamentally if the copy of the work actually resides in the server. There are some logical potential problems with this argument, which have been floating around out there, but this was the highest court that had ruled on it, and it seemed to be the governing ideology by which people made decisions. As long as I don't copy the work onto my server, I'm not infringing. I'm merely embedding it where it's somewhere else. It's analogous to putting a telescope on my roof and allowing it to look at the billboard next door. I didn't make a copy of the billboard. I'm just giving you a telescope to look at it somewhere else. However, two courts have recently challenged this. One was a few years ago in the Northern District of Texas, who said, I don't think that's rightly decided. But as Dallas is not a major entertainment hub, it didn't get that much attention. But this year, I'm sorry, no, it was 2 years ago. There was a case brought against Breitbart on a similar basis. And the Southern District of New York said, you know, I'm not all that persuaded by the server test. You know, it may be applicable in the facts of that case, but the facts here are somewhat different. And I don't necessarily think it matters where the image resides. And everyone went nuts. Everyone assumed this was going to get appealed to the Second Circuit, which is the appellate court that governs New York. But I believe the Second Circuit batted back and it was settled. So we never got a resolution. So it's a little bit unclear whether or not Perfect 10 applies nationwide or merely in the Ninth Circuit, or whether even the Ninth Circuit ruling is not as broad as everyone thought it was, that perhaps it's only narrowed to the facts of Perfect 10 versus Amazon, which are slightly different from this. To add one more wrinkle to this, there have been two rulings in the spring from the Southern District of New York, which dealt with licenses from Amazon. And in those cases, you had a photographer who had posted their work to Amazon. And in the first case, which is called Sinclair versus Zif Davis Media, the court had dismissed their claim, saying, yes, we understand that the defendant had embedded your photo on their website, but we don't even have to consider the server test, because the other issue is they got it from Instagram. And by Instagram's terms of use, you, Mr. Photographer, having uploaded your work to Instagram, have granted Instagram the right to sublicense anybody they want. So this isn't an infringement. That ruling was reconsidered a month or two later, at least in part in light of Instagram's statement that while they were capable of such licensing, they hadn't actually licensed the defendant. And it was walked back somewhat. Meanwhile, in a different case in the same district before a different judge, that judge allowed the case to proceed, did not dismiss, basically saying, well, in essence, we have to see whether a license was actually granted, not just whether Instagram had such a power to grant. So that remains an open question as well. And those, I think, continue to be litigated. But the question of whether embedding constitutes infringement is an active one. And I think it's being actively considered in Europe. And now I hand it to Win to tell us what he knows about Europe.
Okay. Thank you very much, Joshua, for the introduction. But I first, yeah, we are internationally an international copyright enforcement service, so also in the US, and I just wanted to add my 2 cents on the Case Act. In our experience as plaintiffs, then I can only confirm what my colleague Joy Naylor says in the chat, that even if we have lawyers on a contingency basis, the costs can go high, discovery cost, depositions, etc. So we certainly will be very happy to explore the Case Act possibilities, but I'm afraid of the voluntarily basis, as I think Joshua correctly points out, we are just afraid that we will initiate it and the defendants will say, okay, no, thank you, we won't participate. So I'm really looking forward to it. We will explore it for sure, but I'm here to talk about the European point of view. Yeah, maybe to understand us Europeans, let's go back to a long way back to the French Revolution. Why? Well, in the French Revolution, we were all free brothers and we were all equal. But what were we not? And that was Mr. Dallerde that discovered it. We didn't have freedom of trade. We did have guilds. If you wanted to be a baker, you needed to be part of the bakery guild. If you wanted to be a butcher, you needed to be part of the butchery guild. So why is this important for copyright? Well, Monsieur Dallerde, a French revolutionary, a senator back then, he came up with the idea of freedom of trade. He abolished the guilds, and from that moment on, there was freedom of trade, and so freedom to copy. So suddenly you were allowed to do what a bakery does, what a carpenter does. You were allowed to copy, and that idea spread together with the French Revolution, spread throughout Europe, and that's why all the European countries, they think of the freedom of copy. That's the basis. Only there are exceptions. Countries can decide to have exceptions to the freedom to copy, and the most important one is the copyright. So where the basis was throughout Europe, the freedom of copy, all countries started to have their own copyright protection laws. In the 1880s, with the Berne Convention, Europe thought, okay, we need somehow to streamline all these copyright laws, because there was more and more cross-border issues, and the Berne Convention had some main ideas. And the most important idea that entire Europe adhered to was that a work did not have to be registered in order to be copyright protection. As soon as it is original, the work will be copyright protected, and it needs to have a form. So an ID is not copyright protection, but every image, of course, has a form. So as soon as an image is original, a photo is original, it will have copyright protection. Then a long time, nothing happened until the European Union showed up. The European Union, the union of member states, all of individual countries, so not just states, but they are all individual countries, and the emphasis is on the individual country. So, for instance, Brexit, UK decides no longer to be a part of the European Union. That's because it's possible. We are still independent countries, but we have the European Union, and the European Union has 2 kinds of laws. We have the directives and the regulations. The regulations, there the European says, okay, all countries, please abolish your laws, like the GDPR, the General Data Protection Regulation. That's probably feared throughout the US and also throughout Europe. A lot of people heard about it. There, Europe just says, please all abolish your laws. We will write the law for you. But it's not often applied. Most often we apply, or Europe applies, directives. And directives are sets of rules that the countries need to implement in their own laws. So all the laws of the different countries are harmonized on a copyright, according to the copyright directives. It means in the same direction, but in essence, there are quite some differences because of historical differences. But we are progressing all the time in the same direction. And on top, we have the European Court of Justice, the only court that can decide what a directive is and what it should mean. So if whenever there is a question about the signification of a clause in a directive, only the European Court of Justice can speak about that. And yeah, an example thereof is embedding, linking. As Joshua said, it's a hot thing at the moment here in Europe. Why? In 2014, the European Court of Justice was asked to rule about linking. We had two important cases back then, the Svensson and the Best Water cases. With Svensson, what happened there? A website framed, linked to news articles from a news website in such a way that you couldn't distinguish, you couldn't see that the articles actually came from another website. The second one, Best Water, was the embedding of a YouTube video. There, the European Court said, well, there is no new communication to the public for us. If you put something on YouTube, you publish it for the world. The communication is for the world. And if you frame it on your website, if you link to it, there is no new communication to the public, hence no copyright infringement. On the internet, people became very enthusiastic and they thought, okay, the European Court of Justice gave us a free pass. As long as we don't copy the image on our service and we just link to it, frame to it, we are free. And it has been applied for the last 5-6 years, that the people massively shifted from copying the image to the server to embedding it. Now, however, a new case has brought to the European Court, a Bildkunst case, where a website tried to limit the possibilities technically to link, and the question was, okay, is this valid? Now, the Advocate General, the one who advises the court, he said, well, he took a stance against embedding. He says, okay, only if you need to click on a link, then you don't need to have the permission of the author or the photographer. But if you frame an image, a photo, in such a way that you can't see whether it's a local image, an image on a server, or an image from another website, well, then you need the permission of the author. So the Advocate General takes a completely different way, and it's not the court yet, but the courts tend to follow the Advocate General. So that's the biggest evolution here in Europe, where we're all waiting for. In December, the final verdict will be there, and if the European Court follows the Advocate General, what it normally does, well, then there will be an enormous lot of linking cases, because everybody kind of avoids it, because it gives a lot of discussion from a plaintiff point of view. It's not cost effective to go after linking cases at the moment, because there's just too much uncertainty and discussion about it. That brings me to my next point. So in Europe, we do not know punitive damages. We have the civil law system, and that says if somebody harms you, well, the party that harms you should pay you your damages, but not more than that. And we also have that in the copyright directive. So that's a big hurdle, a big, it really limits our possibilities in Europe. If you litigate a copyright case for an image online, your biggest risk is not to lose the case, because normally judges tend to recognize a copyright, and also online. So the big risk is not to lose a copyright case, but the risk is to win it and still lose money. That is the biggest problem. There are differences in between the countries. Like in Germany, the judges are much more likely to follow the tariffs applied by the national photographers organizations, and these are kind of generous. In Belgium, for instance, and in the Netherlands, the judges will not automatically follow these tariffs, and you risk to have, to have to prove your license fees, and you risk to only have your license fee. That's really the biggest problem here in Europe. Then another thing we are experimenting here in Europe actively now is the question about cross-border litigation. What if a photographer that is based in Austria, can he sue someone in Germany? For instance, well, that's a real case that came also to the European Court of Justice. And there the European Court said, yeah, well, yes, it's possible. As soon as there is a point, a reason, an anchor to your country or to a country, the judges there are competent. The only caveat is, the only problem is that the European Court added that they are only competent, the judges are only competent for the damages in these countries. So if you are an Austrian photographer, you can sue somebody in Germany, but only for the damages there in Germany. Also, a problem is that we can't have injunctions that apply for the entire European Union, because a German judge will only be competent to decide on the usage in Germany, and Belgian judge in Belgium, etc. So at the moment we have no European injunctions because the judges don't have European competence. That's another hot issue at the moment, and there are some countries that are more difficult to litigate in, let's say Greece or something there, and so we are experimenting with bringing suits in other countries, because once you've got a ruling, it will be recognized in the other countries, in the other European countries, but the problem is always how can you prove your damages, and will the damages that you will get from a ruling, will they be worth the effort? It's the biggest problem here in Europe.
And I believe Josh wants to make a couple of points on a case related to that very item. So go ahead, Josh.
Yeah, there is a trend there's several lawyers, I think, in Germany who have been sending notices or demand letters to foreign infringements, foreign defendants rather, claiming infringement and claiming rights to bring suit under German law in Germany for infringements by, let us say, for the purposes of discussion, an American website, which has no other connection to Germany except being viewable in Germany. And they're citing that the Austria-Germany case that Wen had mentioned. And it does appear, indeed, that they have been able to convince trial level courts in Germany that they have jurisdiction over foreign defendants who have no other connection with Germany except having a website viewable in Germany. The question that has arisen, and to my knowledge has not yet been tested, is whether a US court presented with a default judgment from a German court based on jurisdiction asserted on the basis of, well, you can see the website from Germany, is going to be enforceable. My instinct is that it is not. There is a case from the Ninth Circuit doing the reverse, where you had a US photographer bringing suit against the German defendant, where the German defendant had taken the photograph belonging to the US photographer, put it on his website in Germany. And the American photographer had brought suit in California seeking damages. And the court, of course, the German defendant, who was an individual, didn't appear to defend, so he was seeking a default judgment. And the trial court in Los Angeles said, I don't think we can enforce this, and we're not going to issue a default judgment where we think it would be unenforceable according to constitutional norms, which, you know, the due process clause of the Constitution requires fair play and substantial justice and minimum contacts with the forum state, which is to say, it's not enough probably that it can be seen from here. You'd have to actually have some sort of a business connection related to this issue between the place where the suit is being brought and the defendant. So I have my doubts that presented with a German trial court ruling for damages, and the damages can be substantial because the German Photographers Union issues a guidebook to average costs of licensing every year, and that guidebook has been apparently generally accepted as a reasonable guide to damages. So you can get damages in excess of 10,000 euro for a single image potentially. And it includes a small award of attorney's fees under German law. So you end up with something like a 10,000 euro judgment that would, in theory, be presented to a US court saying, hey, please enforce this judgment that we got in Germany. But I have my doubts that a US court will accept it.
Okay, folks, so those are the hot topics from our three roundtable presenters today. It's now your turn. If you have any questions, our presenters are open to answering them or giving input for you. So you can just click in the chat and let us know you have a question, or you can raise your hand and we will come and give you an opportunity to ask your question.
Sonia?
Yes.
So I noticed that in the chat, somebody was disputing Josh's view that it is easy, to bring a claim and that people just kind of go away. And I will say this is not, I will give the disclaimer, this is not the Copyright Office position. This is just my personal experience. Before I was at the Copyright Office, I actually was a litigator and litigated these kinds of things. And often you would think something would be easy, it should be, this is clear. And depending on the other side, there could be some irrational behavior sometimes. So, or maybe not irrational, maybe it's totally rational to want to, make sure that you are doing a certain thing. So my experience when I wasn't doing really large, large company versus company things is there were a lot of individuals. When you go against individuals, it was a lot more unpredictable. And I actually went to trial with one that I was a little surprised, like, okay, we're going all this way. But I don't think that it's as easy to get people to kind of, not go through the process as Josh mentioned. And so I tend to agree a little bit with that. And I also wanted to point out that Josh mentioned this is for like a black and white claim. Well, what percentage of infringements are super open and shut, that you wouldn't have something that you wouldn't want to have some more information on it. They could be completely legitimate and meritorious, but would require a little bit more. And so for those, that's also an issue for the federal court system as it is right now.
Okay. Go ahead. I actually have a question relating to this, and I don't know the answer. In federal court, a corporate entity cannot appear on its own behalf. It must appear through counsel. Would that apply to the small claims tribunal? Because it's not addressed in the act.
I'm not sure either, Josh, so I'd have to look into that. I'm not going to say something that is incorrect.
No, I don't know the answer either, but if that's the answer, then it turns out that at least a lot of these litigants are going to end up needing lawyers anyway.
Well, if you're a company, right, that's true. If you are...
I'm sorry, go ahead.
We do have a question from our audience, if we can move on to that. And that is that regarding the Case Act and the Small Claims Copyright Court, what is the incentive again for a defendant to not opt out of the process?
Okay, I think that I'll take that one because I think Josh has a different take on it than I do. So there are a couple of incentives. Number one, the damages are much lower than in a federal court. So instead of being able to go up to $150,000 for statutory damages for a registered claim, or however much if you can prove actual damages, right? Sometimes those can actually be quite high. You are limited to $30,000. And so that is a much smaller damage cap than you could be exposed to in federal court. It also has a smaller statutory damage than in federal court. So $15,000 per claim for statutory damages. So that is also an issue. And then there is the issue of, do you want to have to defend yourself in a federal litigation, which can take a lot of resources and time and a lot more difficult than just doing it through a more streamlined process. So those are a couple of the incentives for why you would want to stay in the small claims tribunal.
I have a question for you, Katie. When the ruling was made that an image had to be registered in order to actually bring suit in federal court, did the Copyright Office see an influx of image registrations coming in?
So you're talking about Fourth Estate. Is that the Supreme Court Josh was talking about? I don't know. So I can't answer that question for you because I don't have access to those particular statistics. I will say that one really great thing we've done at the Copyright Office, if I can toot our horn, is that we have really reduced processing times a lot. So people were a little worried about that in the case, and some of the litigants were. And actually, just the late Justice Ginsburg had she authored the opinion, and she was talking about how, it is, you have to look at the situation based on the law. And the law says, according to them, the Supreme Court, it is a registration. And so, we now are much quicker. I think the last I saw it was like 2.6 months for an online claim, which is really not bad at all. And then, we also have, if you are in an emergency situation, you can always ask, you can always get expedited handling. It's more expensive. So you'd want to be sure that it was, you probably wouldn't want to do it for something like a $500 claim or anything, right? Because you have to pay more than that to get expedited handling. But that is an option if you really need to get in, like, immediately.
If one thing I would just add to that is that you always had to register in order to bring your suit. The question is whether your registration had to have issued. And Katie's quite right. The processing time has gone way down, but 6-7 years ago, it was many months. It was 6 or 7 months or something. And yeah, you can get an expedited issuance. I think it's several $100s. And it becomes an issue if you're getting close to the statute of limitations. You're thinking, I got to file this week, but I haven't registered. So now instead of paying the $35 or $40 to register, I have to pay $940 to get an expedited registration. That's the significance of it.
Yeah, and I will say, Josh is right. So previously, you would have to, I actually will say you don't need a registration. You need us to make a final decision, right? So
no, yes.
If we say no, we don't think your work is copyrightable, you can still sue. You just will not have a registration and all the presumptions that kind of go with that. So you might have a harder road ahead of you if you can't get a registration from us. But basically, previously, there were some courts that said, okay, once you apply, you can start the process versus having to wait for the registration. So you always had to talk to us and apply. The question is, at what point in that process are you able to go to court? Do you have to wait for a decision or not? And so basically now you wait for us to make the decision, yes or no. And actually people do bring suits if they don't get registration. That happens. And actually we get sued when people don't like that we refuse the registration. So happens all the time, actually.
Okay, Katie, we've got a question for you now from Joe Naylor, and it is there any possibility for a change that would allow the registration of groups of published 2D artworks like illustrations? The single work limitation is a huge cost barrier to illustrators and other artists registering their bodies of works.
So I am familiar with this concern and I appreciate it. So, one thing that is a little different than some other types of works, like if you think of a movie or something like that, they don't make as many as people who take photographs or people who do illustrations. Graphic artists often do a variety of versions that they would want to protect, but they don't really have the means or the wherewithal to apply for each thing. So currently we don't have a group registration for 2D works that are not photographs. So there is a group option for photographs, but not illustrations right now. We are looking into that and we are in the middle of modernizing our system. If you keep an up to date with our stuff. We're in the middle of doing that. We had a notice of inquiry actually on the Federal Register. I guess it was like a year ago it closed, or maybe two, where we posed a bunch of questions like that. So we were thinking about it, and it's definitely on our radar. I cannot say, you know, we are totally going to do it or we're totally not going to do it, but it is something that we're aware of that has been raised. So it is definitely something we're thinking about.
Okay, I also noticed about 2 weeks ago, we corresponded from our company to the Copyright Office with a question, and we got a disclaimer that said, due to COVID, the Copyright Office needed 5 business days in order to respond, but the actual response took almost 2 weeks. Is there any effort on the Copyright Office's side to try to reduce that time period as well?
So I'm not going to opine on an individual matter, and I'm not sure exactly what kind of correspondence you were talking about. But we actually have done a lot to address the pandemic. So obviously it's a big deal everywhere, including, you know, the Copyright Office. Although we are probably not at the top of the list that you think of when you think of pandemic-related issues, right? So, but we are, you know, our office is closed to the public in March. And we have now some of our employees back in the office, but that was not, I mean, that took several months. And now most of us are still working from home, as you can see. So most of us are not there, and that does impact some things, but we have made a lot of headway on other things. So without knowing the particulars of that, I will say we have a coronavirus page on our website, copyright.gov/coronavirus. And you'll see there that we do have some accommodations for like deposit materials. So if you are in the situation where you have to provide a hard copy deposit, we have some information up there that can help you with getting your things through a little quicker than having to wait for all of that. But we are trying our best to move things along and respond as quickly as we can.
Great. Well, we have about 3 minutes left on our timing. I'll give one more opportunity for any additional questions. If not, if the panelists have perhaps a parting comment towards the subject, we'd be happy to hear from you. Katie, any closing remarks?
Any closing remarks? You know, at the office, we really aim to work for the public. That is our mandate. Our mission is to fulfill the constitutional mission promoting the progress of the sciences and useful arts. And so that is what we strive to do. If there are any things that you would like help with, you know, please give us a call. We have a public information office that is open 5 days a week, and you can always email us as well. And, you know, we really are here to help. We are here for the public. So I guess the one thing I would say is that if you need us, please reach out to us. Now, are we always going to agree with you? Maybe not, but we definitely want to hear from you, and we want to provide a fair response. So I know that these are not the greatest times, but you know, our point is to help copyright generally the system and to help everyone in it.
And Joshua, any closing remarks?
I don't want to drag this out. I want to amend slightly what I said about the Case Act. I'm not saying it has no value. I'm saying that, or my position is that in the context of the cases that I've seen that relate to image rights infringement, in my experience, it seems like I would advise a client in almost every situation, don't go to the small claims court. Because as a plaintiff, I think it limits your firepower, and as a defendant, the only advantage, it would be unlikely to advantage you unless the plaintiff hasn't figured out that it would limit his firepower, in which case, yeah, sure, go through it. But it seems that if you had canny players on both sides, very few cases of these kinds would go through the small claims court.
Okay. And Ewan, do you have any closing remarks?
Well, in my experience, the infringers, they always become more and more knowledgeable. They find more and more information on the internet. So whereas a couple of years ago, you could send out a letter and the infringer was scared and paid quickly. I think these days are a little over. I think we have to motivate a lot more and to fight a lot more for our claims to get the money in, just because on the other side the people are getting more knowledgeable. It's not just us that keep on doing a better and better job. The infringers still get more knowledgeable, and I guess that's good and fair.
Okay, well, we appreciate everyone taking the time this morning to join us, and special thanks to all three of our panelists for their time today. And let's go forward and protect our images. Thank you all.